Magandang araw. This is our video discussion of module number 12 for BAM242. So our lesson title is Real and Chattel Mortgage, and these are our lesson objectives. So at the end of this module, I can state the definition, characteristics, requisites, and subject matter of real mortgage and chattel mortgage, explain the extent of mortgage, and understand the foreclosure and redemption of mortgage, and lastly, distinguish between chattel mortgage and real mortgage. So this is our productivity tip, very simple yet very powerful words. We are what we repeatedly do. Excellence then is not an act, but a habit. Aristotle. So despite the fact na nandiyan lang kayo sa inyong mga tahanan, sana magkaroon pa rin kayo ng study habits. Kasi there's no way to greatness, but greatness is the way. Talagang kailangan magkaroon kayo ng magandang habit ng pag-aaral. Para nang sa ganon, you will just going to reap the harvest of your hard work. Okay, so let's go on with our topic for today. So here is our lesson preview or review. Contract of pledge and contract of mortgage share the same concept. Both are accessory contracts, which purpose is to secure the fulfillment of a principal obligation, which is normally a loan extended by a creditor to a debtor. So you may wonder, if the two contracts share the same concept, what makes them differ from each other? So well, the difference boils down to the properties that may be the object of the contract of mortgage. You learned from our previous lesson that the object of the contract of pledge is, ano na nga, ang ating object ng contract of pledge? You are correct. Personal properties or movable properties as well as incorporeal rights. Ayan. So these personal properties may include movables provided that they are susceptible of possession and incorporeal rights. In contract of mortgage, the object is strictly confined to immovable properties. So it's also known as real mortgage. Ayan. Pag sinabi kasi natin na, kaya malilito kasi dalawang klase yung mortgage na ginagamit. No? Pwedeng chattel mortgage, pwedeng real mortgage. Pero actually sa law parlance, pag sinabi nating mortgage, automatically real mortgage ang pinag-uusapan. So, ganun yan ha. So again, pagdating sa law parlance, pag sinabi nating mortgage lang, not really mentioning whether it is chattel mortgage or real mortgage. So actually, ang presumption, we are talking about real mortgage. Okay? So next, in this module, you will understand the definition of contract of mortgage and be able to enumerate the different kinds of mortgage and essential requisites of contract of mortgage. Likewise, you will also learn the effects and extent of mortgage and the concept of foreclosure and redemption of foreclosed property. Okay, new terminology, foreclosed. Usually sa bank niyo yan na-encounter na foreclosed yung property o yung bahay at lupa ni A o ni B, ano? Ibig sabihin, sa Tagalog, nailit, na foreclosed. Ayan. So ang ibig bang sabihin ay pwede na i-appropriate ng bangko yung foreclosed property sa kanyang sarili? Diba sa contract of pledge, hindi. This time around, sa mortgage kaya, sa contract of mortgage kaya, pwede kaya yung ganun? This and more you will learn in this particular module. But for now, please pause this for a while and answer the what I know chart. Okay, so let's go and move on to our main lesson. What is contract of mortgage? So mortgage, otherwise known as real estate mortgage or real mortgage, is a contract whereby the debtor secures to the creditor the fulfillment of a principal obligation, especially subjecting to such security immovable property or real rights over movable property in case the principal obligation is not complied with at the time stipulated. Okay, so like I said a while ago, yung contract of pledge and contract of mortgage shared the same concept. pareho ba na ipiniprenda nila yung property for security of the fulfillment of principal obligation? So, lagi namang loan yun, ano? Most of the time. Contract of loan yung sinisecure. Ayan. So, sabi ko nga ulit na naman na ang pagkakaiba lang ng dalawa talaga ay yung object involved. Kasi sa pledge, movable property, sa mortgage, immovable property. Yun yung major differences between the two. Actually, meron pa. There's more differences between the two. However, yun yung prevalent o yung pinaka-obvious na difference between the two. May pag-usapan natin. Okay, so as the definition suggests, a mortgage is a contract wherein an immovable property or real rights over immovable is given as a security for a loan extended by the creditor to the debtor. So like contract of guarantee, the debtor need not be the owner of the thing being mortgaged because a third person may offer his own property to secure the debtor's obligation. So siguro to like contract of pledge. Okay. Like contract of pledge, not guarantee. Why? Kasi 'di ba sa contract of pledge, pwede naman na yung ipine-pledge na bagay ay hindi talaga pag-aari ng debtor. In fact, if you are a friend of a debtor, tapos napakiusapan ka na pwede bang, i-prenda nga natin yung singsing mo para sa utang ko. Tapos pumayag ka. Is that valid? Is the pledge valid? The answer is yes. Okay? The answer is yes. Why? Because for as long as the third person is the real owner of the thing pledged, then the pledge is valid. So ganun din sa contract of mortgage. Hindi kinakailangan na sa debtor talaga yung property na isasangla or ipiprenda. O pwedeng pagmamay-ari siya ng third person na pumayag na iprenda yung kanyang gamit as a security of a loan. So I hope naintindihan niyo yan. Pero here is an example. So C, the creditor, extended 500,000 loan to D, the debtor. So this is a contract of loan. T, a third person, not party to the contract of loan, agreed to give as security his own house. There goes contract of mortgage. So from here, you will learn that what matters is that the one entering into the contract of mortgage owns the property. So for as long as it is really T who owns the property, then it doesn't matter, no? Okay lang yon. Magiging valid pa rin yung contract of mortgage kahit na yung kanyang parang sinisecure na loan ay hindi naman talaga kanya. So, these are the characteristics of real mortgage. So, first and foremost, it's an accessory contract. By now, I know na alam nyo na kung ano ibig sabihin ng accessory contract. It is a real contract. Bakit? Because it is perfected by the delivery of the thing. It is a unilateral contract, just like contract of pledge. Why? Because it creates an obligation only on the part of the creditor who must free the property from the encumbrance once the obligation is fulfilled. So, let's move on kasi alam ko, easy lang sa inyo yung characteristic of real mortgage. So, ano bang subject matter ng real mortgage? Article 2124, only the following property may be the object of contract of mortgage. Siyempre ay immovables. And then next is alienable real rights in accordance with the laws imposed upon immovables. Nevertheless, movables may be the object of a chattel mortgage. Ayan. So, as we all know, meron ding isa pang klaseng mortgage, chattel mortgage naman, which objects are movable properties. So kasi dito, basta huwag kayong malilito kapag sinabi natin real mortgage, from the term itself, real, no, it must be immovable or rights pertaining to immovable properties. Yun lang siya. Kapag yung mortgage, ang naging subject matter ay movable properties, chattel mortgage yun. Okay? Yun naman yung pag-uusapan natin. I don't know, next module ba o dito rin sa module natin? Parang dito rin yata. Okay, so let's talk about kinds of real mortgage, not kinds of mortgage ha. Ang sabi dito, kinds of real mortgage. Kasi pag sinabi natin kinds of real mortgage, voluntary, legal, at saka equitable mortgage ang ating pinag-uusapan. Ano ba yung voluntary tsaka legal? O sabi ko na sa inyo dati, 'di ba? This is general. Kapag sinabi natin na voluntary, this is as agreed upon between the parties or as stipulated by the parties. O that is voluntary. Other term is conventional. Ayan. Next, legal. One required by law to be executed in favor of certain persons. And then we have equitable mortgage. Ayan. One which, although it lacks the proper formalities of a mortgage, show the intention of the parties to make the property as a security for a debt. Ito kasi yung presumption. Importanteng malaman nyo. In practice. Kasi there are times, lalo na kapag kayong mga tao ay very vulnerable members of the society, and these are the uneducated people, uneducated but doesn't mean that they don't have manners. Uneducated meaning hindi lang sila nakatungtong sa paaralan. And in that case, hindi sila apprised o hindi sila familiar sa mga bagay-bagay kagaya ng bentahan ng lupa. Ayan. So kapag ka nagkaroon ng doubt, sa whether yung pinasok na contract ay sale with right of redemption o secure or ibinigay lang as security for loan ang isang lupa, i-resolve siya in favor dun sa mas hindi onerous dun sa tao. So, ipagpapalagay siyang equitable mortgage. Anong point natin dito? Ma'am, ano po ba yung pinagsasasabi niyo? Hindi na po namin naiintindihan. Okay, ganito siya. May mga vulnerable members of the society na ang totoong pinasok lang nila talaga, ayan, ay halimbawa, gusto lang talaga nila minsan isang lot. Kaya lang, inilagay doon, example ay parang contract of sale na. Sabihin na natin na somehow ay pwede na may cloud o malabo yung usapan. Kasi yung sale with right of redemption, ito ba yung ibinenta yung isang bagay, kung matatandaan nyo. Diniscuss natin yan sa law on sales. Ibinenta mo yung isang bagay pero with the intention of buying it back. Ang magiging problema kasi doon, pag binenta mo, may transfer ng ownership, tama. Tapos, kung i-exercise mo yung right mo for redemption, at saka pa lang, maibabalik sa'yo, marirevert back sa'yo yung ownership. So again, di ba ganun yun? Kapag sale with right of redemption, yung ownership ng property ay matatransfer na agad sa bumili. Ayan. Paano kung hindi talaga yun yung intention? Ang intention lang talaga ay as security for a loan. So, kapag yung papeles, yung documents, ay medyo malabo o may doubt, o medyo parang kulang sa linaw, okay? Then, ang presumption ay yung mas hindi onerous doon sa tao, which is equitable mortgage. Bakit? Kasi yun yung mas magaan. Kasi ibig sabihin yung ownership hindi talaga niya pinapasa, but instead it is just a security for a loan. Ayan. Bakit ko ba yun tinatch? Kasi yung topic na yan, ito talaga yung isa sa pinaka nangyayari in real world kung saan madaming nagkakalokohan dahil ang akala lang nila, isinasangla nila yung kanilang lupa, nung pala parang ang ginagawa ng papeles ay sale with right of redemption lang. Which is so bad dahil ang ibig sabihin doon ay natatransfer na yung ownership from the very beginning that the person signed the contract. Okay ba yun? So sana may natutunan kayo doon. Okay. So pag-usapan natin essential requisites of real mortgage. These are the essential requisites of real mortgage, constituted to secure the fulfillment of principal obligation. The mortgager be the absolute owner of the thing mortgaged. The person constituting the mortgage have the free disposal of their property, and in the absence thereof, that they be legally authorized for the purpose. Number 4, it is indispensable in order that a mortgage may be validly constituted that it appears in a public document duly recorded in the registry of property. Though even if it is not recorded, it is still binding between the parties. However, it will not be binding against the whole world. Okay. So these are the essential requisites of real mortgage. Alam nyo, total naman, hindi naman ganun kahirap na magpanotaryo, panotaryo nyo na din. Hindi na rin naman ganun kahirap magpa-register sa Registry of Property, iparehistro nyo na din. Kasi minsan, may mga tao na sinasangla nila yung isang property sa multiple people. No? Ayan, mahirap yun. So, effects of real mortgage. Article 2126. The mortgage directly and immediately subjects the property upon which it is imposed, whoever the possessor may be, to the fulfillment of the obligation for whose security it was constituted. So, immediately ang effect ng real mortgage. So, the contract of mortgage creates real rights, which is enforceable against the whole world. Okay, so even if the mortgagor sells the mortgage property, the property remains subject to the fulfillment of the obligation secured by it, provided the said mortgage is registered with the Register of Property. So from this very scenario, you would know for a fact na isang nasanglang property pwede pa rin ibenta ng nagsangla. Bakit? Siya pa rin kasi may-ari. Okay, so ganito. May property ako, sinangla ko sa'yo. Okay. Habang nakasangla sa'yo, ibinenta ko sa iba. Is the contract of sale I entered into with another person is valid? The answer is yes. Why? Because I am still the owner of the property. I can do whatever it is that I want to do with the property. Pero, yun lang. Even if the mortgager sells the mortgage property, the property remains subject to the fulfillment of the obligation. Kaya wala ka naman talagang dapat ikakaba. Kasi pag di ako nakabayad sa'yo, meron ka pa rin lien over the property. Why? Kasi hindi naman po pwedeng porket na irit, ibig sabihin sa'yo na. Hindi mo naman din talaga siya pwedeng i-appropriate for yourself. All we have to do for the property is to sell it in public auction so that whatever the proceeds may be, will be appropriated between the two of us. So, ganun yun. Okay, the contract of mortgage creates merely an encumbrance. So, actually, tatatakan lang yung original na nasa Registry of Properties, no? Tatatakan lang ng encumbrances, meaning to say, para alam ng mga tao, no, bilang hudyat sa mga tao na ang property na to ay may mga encumbrances, may mga sa madaling salita ba ay may mga sabit, no? May mga issue, mga ganun. Ito ay nakasangla dito, ito ay nasangla sa mga ganyan. Kasi lahat ng history ng encumbrances nakalagay doon sa likod ng titulo. Okay. So, anong sabi rito? The law considers void any stipulation forbidding the owner from alienating the mortgage immovable. Ma'am, paano po? Halimbawa, yung isinangla nyo sa aking property, di ba? Naalala mo, example ko, nagsangla ako sa ng property, gusto ko ibenta sa iba. Binenta ko sa iba, is the sale valid? The answer is yes. Ngayon, ang question, ma'am, paano po kung may usapan tayo na dapat huwag nyo ibebenta sa iba? Hindi nyo pwedeng ibenta. Is that stipulation valid? The answer is no. That stipulation is void because it is against public policy. Nakalagay pa nga dito, the law considers void any stipulation forbidding the owner from alienating the mortgage immovable. So even though may usapan tayo, pwede pa rin ba siyang ibenta sa iba? The answer is yes. Bakit? Kasi yung usapan natin ay void. Ayan. Next, extent of real mortgage. Article 2127, the mortgage extends to the natural accessions, to the improvements, growing fruits, and the rents or income not yet received when the obligation becomes due, and to the amount of the indemnity granted or owing to the proprietor from the insurers of the property mortgage, or in virtue of expropriation for public use, with the declaration, amplification, and limitations established by law, whether the estate remains in the possession of the mortgagor or it passes into the hands of a third person. So this provision clearly provides the extent of contract of mortgage. It is not limited to the property itself, but also extends to the thing as mentioned above. Pag sinabi nating extend to the things that are mentioned above, ibig sabihin, ang mga bagay na to ay kasama sa mortgage. Ayan. Okay, so pag-usapan natin yung foreclosure ng real mortgage. By foreclosure. Foreclosure, it is actually a remedy. It is a remedy available to the mortgagee. Okay, mortgager yung nagsangla, mortgagee yung tumanggap, the remedy available to the mortgagee by which he subjects the mortgage property to the satisfactions of the obligation to secure, which the mortgage was given through the sale of the property at public auction and the application of the proceeds thereof to the payment of his claims. Simply put, foreclosure is where the property mortgage will be put on sale and the proceeds derived from the sale will be used as payment for the loan. Kasi imagine niyo naman, lagi naman kasi customary na kapag halimbawa isang bagay, ipeprenda mo, usually mas malaki pa rin yung value nung ipeprenda mo kaysa dun sa amount na inutang mo. So, maitry nyo lang ha. Diba yung alahas, halimbawa na worth 100,000, hindi mo naman may sasangla ng 100,000 yan, di ba? Sasangla lang yan siguro mga kalahati ng value or less pa. I don't know, I haven't tried na magsangla. Yun ang point ko. But I am very sure na hindi yan papayag na isangla sa same halaga. Or else, contract of sale na yan. Di kasi fair market value na. So, going back to the real usapan, ang sabi dito, hindi mo po pwede i-appropriate sa sarili mo yung isinangla sa'yo. Instead, ang remedy mo lang talaga pag di ka mabayaran ay tinatawag na foreclosure kung saan yung property na minortgage sa'yo ay i-auction. Ayan. So that any proceeds derived from the sale at the auction will be used for the payment of the loan. Ayan. For the payment of the loan. Okay. So, usapan natin kinds of foreclosure. May tinatawag tayong judicial tsaka extrajudicial. Pag sinabi natin judicial, ibig sabihin yung court na kailam na o involved na. Pag sinabi ng ating extrajudicial, ito lang partido. Okay? So, pwede kasi na ipasok na sa contract or i-include sa contract yung isang clause na nagbibigay ng karapatan o kapangyarihan dun sa mortgagee na kapag nag-default yung debtor, pwede na niya i-foreclose yung mortgage property sa pamamagitan ng extrajudicial sale. Alam niyo, mas maganda yung ganon para mas hindi magastos, mas practical. Kasi di ba kung wala kayong ganong usapan sa kontrata, mapipilitan ka pa ulit na na kung hindi mo siya makausap mabuti, pipilitan ka magpunta ng korte. Yun nga, kaya magiging parang judicial yung foreclosure. Pero huwag kayong mag-alala. Kung kayo naman yung may-ari ng property na na-foreclose, meron naman tayong tinatawag na redemption of foreclosed property. Baka pwede mo pang maagapan na makuha ulit. Sabi rito, redemption. It may be defined as a transaction by which the mortgagor owner of mortgaged property reacquires or buys back the property within a certain period and for a certain amount after his default or after the foreclosure sale of the property for the satisfaction of mortgage debt. So you see, na foreclose na pero nahahabol pa, pero hindi ito forever. No, may limited time lang ito. No? May certain period of time lang ito. Okay, ano daw yung redemption? Yung daw nagsangla, o mortgagor owner, kaya sinabi mortgagor owner because you cannot mortgage what you do not own. You must be the owner of the thing mortgaged, di ba? Kaya sinabi ito mortgagor-owner. Ayan. O pwede pa rin niyang i-reacquire o bilhin, pabalik sa kanya, yung property for a certain period of time after his default or after the foreclosure itself. Ayan, tignan natin to. So even though real mortgage and chattel mortgage share almost the same concept, their subject matter is different. And there are provisions applicable to real mortgage that are practically not applicable to chattel mortgage. So real mortgage subject matter is confined to immovable and real rights in relation to immovable property. So on the other hand, chattel mortgage subject matter is personal property. You might want to ask, but contract of pledge subject matter is personal property too. Is chattel mortgage and contract of pledge the same? The answer is no, they are not the same. The two contracts share the same subject matter, but there is distinct difference between the two. Contract of pledge, you can recall, the delivery of the thing pledge is necessary. But, okay, chattel mortgage, delivery of thing is not necessary. Nakikita niyo na ba yung buong picture dito? Pledge, chattel mortgage, real mortgage. Pledge, movable property. Real mortgage, immovable property. Chattel mortgage, movable property. Pitikin muna natin yung real mortgage. Pagtabihin natin yung pledge at saka chattel mortgage. Parehong movable yung property na involved. Parehong nagsisecure ng loan. So, ano pagkakaiba ng dalawa? Naalala nyo, si pledge, kailangan yung possession ng thing pledge, he must deliver the thing pledge to the creditor. Yung chattel mortgage, you need not deliver the thing. Hindi mo kailangan i-deliver yung thing. Yun yung pagkakaiba ng dalawa. Again, pledge, chattel mortgage, parehong movable yung thing na involved. Anong pagkakaiba ng dalawa? Kung pareho naman pala sila nagsisecure ng principal obligation. Ang pagkakaiba ng dalawa, yung thing na pinledge, kailangan i-deliver mo dun sa creditor. Yung chattel mortgage, yung thing na subject matter ng chattel mortgage, hindi mo kailangang i-deliver. Okay? Okay tayo doon, ha? Yun yung pagkakaiba ng dalawa. Yung thing na pledge, yung thing na pinledge, pag dineliver mo sa creditor, di niya pwedeng gamitin, ha? For safekeep lang yun talaga. Okay. Yung chattel mortgage, hindi niya dineliver. Nasa kanya pa. Okay? Nasa may-ari pa. Naka-chattel mortgage lang. Sino gumagamit? Siya. Yung may-ari. So ano lang yung hawak nung ano? Ano lang yung hawak nung pinag-mortgagean o nung mortgagee? Ano lang hawak niya? Papel lang. Papeles lang. Okay. Sabihin ko kayo example. That is why, usually sa Pilipinas, kapag naglabas ka ng sasakyan, may chattel mortgage yan. Hindi sila papayag na hindi mo i-insured yung sasakyan habang yan ay hinuhulugan mo pa. Okay? Bagong sasakyan pinag-uusapan natin na. Bakit? Para pag nabangga yung insurance, magbabayad siya. At least kung sakaling hindi ka na makahulog, alam mo yun, meron pa rin makukuha, hindi pa rin malulugi yung mortgagee kasi meron siyang makukuha sa insurance. Bakit? Kasi nga nabangga yung sasakyan, hindi na napakinabangan o yung mga ganon. Okay? So, okay. Let's move on. So, Article 2140 by the Chattel Mortgage, personal property is recorded in the Chattel Mortgage Register as a security for the performance of an obligation. If the movable, instead of being recorded, is delivered to the creditor or third person, the contract is actually a pledge and not chattel mortgage. Okay, so example of chattel mortgage. Ayan, ito. Sinabi ko naman na talaga sa inyo itong example lang. Okay, pag-usapan na natin yung characteristic ng chattel mortgage. Siyempre, accessory contract siya, but it is a formal contract. Okay, formal contract. Because to be valid, you need to register the chattel mortgage. Unlike yung real mortgage, you have options. Kung gusto mo i-register sa register of property, pwede. Kung ayaw mo, pwede din. Ano lang magiging problema mo doon? Pag di mo pinarehistro, hindi siya enforceable against the whole world. That's just between you and the other person. Pero valid siya. Pero sa chattel mortgage, to be valid, you need to register the same to the chattel mortgage register. And it is an indispensable requisite. Ayan. So, pag-usapan natin yung chattel mortgage, it is unilateral contract. O hindi yung parang yung ano din, unilateral din naman yung pledge at saka yung real mortgage, di ba? So, lahat silang tatlo, accessory contract. Pero ito lang talaga yung formal contract. Yung pledge kasi need not to be in writing. The delivery of the thing itself is sufficient. It is perfected by the delivery of the thing. It doesn't necessarily needed to be in writing talaga. Why? Because contract is just between, it is actually meeting of the minds. Okay, so, eto na-discuss ko naman sa yung difference between chattel mortgage and contract of pledge. Usapan natin yung foreclosure of property. Ito tayo ha. Baka naliligaw kayo. Foreclosure. When the proceeds of the sale is more than the principal obligation. Okay. Kasi di ba pag sinabi natin foreclosure, this is actually a remedy available to the mortgagee. Di ba? Available yan sa pinagsanglaan. Ngayon, ano bang ginagawa sa foreclosure? Di ba? Ibinibenta yan. Ideally sa public auction. Kaya lang, may senaryo kasi yan dalawa. Pwede na ang mapagbentahan mo malaki, pwede mapagbentahan mo maliit. So kung ipaghalimbawa natin na ipagpalagay natin ang napagbentahan mo daw, sabi rito sa letter A, ay more than the principal obligation. Sa chattel mortgage, yung excess, papupunta sa debtor. Pero sa contract of pledge, yung the debtor daw is not entitled to the excess. See the difference? Ano na po yung excess? Jadi, dun na sa pinag-pledgean. Okay, so letter B. What if less than the principal obligation? Sa chattel mortgage, yung creditor is entitled to recover the deficiency. So, ibig sabihin, sa chattel mortgage, kapag less than yung napagbentahan, may utang pa rin si debtor. Pero sa contract of pledge, ang ikinaganda, wala na. Wala nang karapatan si creditor na makarecover ng deficiency from the debtor. Yun naman din ang ikinaganda dyan. Kasi kapag naman higit yung napagbentahan, kanya naman lahat. O bakit ngayon kapag kulang yung napagbentahan, sisingiling ka pa. So, just to be fair, kapag sobra, kabi kanya lahat. Pag kulang, sorry na lang. Ayan. Sa contract of pledge yun. Ha? Pero sa chattel mortgage, kapag sobra, solely sa debtor, pag kulang, may utang si debtor. Okay. So, Article 2141, the provision of this code on pledges so far as they are not in conflict with chattel mortgage law shall be applicable to chattel mortgages. Okay, so similarities between chattel mortgage and contract of pledge. They are both executed to secure performance of principal obligation. Check, alam na alam niyo yan. They are both constituted only on personal property. Alam niyo. The creditor cannot appropriate the property to himself in payment of the debt. Check, alam niyo na yan. If the debtor failed to pay the principal obligation, the property given as security must be sold for the payment of the creditor. Foreclosure yan. Ayan. Both are extinguished by the fulfillment of the principal obligation. So those were the similarities between chattel mortgage and contract of pledge. Alam ko, malinaw sa inyo yung lima niyo. Okay, paano ba nakikreate ang chattel mortgage? Kahaba pala nitong module number 12. Okay, so creation of chattel mortgage. There is only one way for executing a valid chattel mortgage. A valid chattel mortgage is created by the registry of the personal property to the chattel mortgage register as a security for the performance of the obligation. Anong point natin dito? Pag hindi nakarehistro sa chattel mortgage register, ibig sabihin wala kang valid chattel mortgage. So walang chattel mortgage. Ayan. So saan natin nire-rehistro? Under chattel mortgage law, if the property is situated in a province different from that in which the mortgager resides, the registration must be in both sorry, parang may kulang dito sa sinasabi. Sa parehong provinces. Otherwise, the chattel mortgage is void. Okay. So, kung nasaan yung property o kung nasaan din yung, kung magkaiba yung lugar kung saan matatagpuan yung property at saka kung saan nakatira yung mortgagor, dapat irerehistro mo yung chattel mortgage sa same province na yun. So, kung yung halimbawa, yung sasakyan nasa Manila, doon na talaga ginagamit. O kaya tapos yung tao naman ay nakatira dito at magkahiwalay silang dalawa, sila magkasama, yung sasakyan sa yung tao. Rehistro mo na pareho dun sa magkaibang lugar na yun. Ayan. So, ano ba kasi implication pag hindi mo nirehistro in both places? The mortgage is void. Usapan natin yung foreclosure ng chattel mortgage. Foreclosure. Ang lungkot niya, goodbye car, sabi. Tapos ayun na yung car niya, pina-public auction. Okay, the purpose of the chattel mortgage is to secure the fulfillment of the principal obligation. So needless to say, once the principal obligation has been paid for, the mortgagee must discharge the mortgage in the manner provided by law. Otherwise, he may be held liable for damages by any person entitled to redeem the mortgage. It is also important to remember that if the debtor defaults in the payment, the creditor cannot appropriate the thing to himself. Again, the chattel mortgage, if the debtor defaults, it doesn't mean that the creditor can appropriate the thing to himself. Ang general rule natin is that the creditor cannot appropriate the thing to himself. Okay. So it means that the creditor will not automatically become the new owner of the thing when the debtor failed to pay his obligation. What happened is that when the debtor defaults in the payment, the creditor may cause the thing to be sold at a public auction. The creditor can recover the amount owing to him from the proceeds of the sale of the property. So in case the proceeds from the sale exceeds the amount of the obligation, the excess must be given back to the debtor. On the other hand, if the proceeds of sale is less than the amount of the obligation, the debtor must pay the deficiency. So again, pagdating sa chattel mortgage, pag pinag-uusapan natin yung foreclosure, ibinenta yun sa public auction, just like what we've learned a while ago. Kapag ka-excess sa utang yung napagbilan ng sasakyan, kailangan yung excess na pinagbilan isoli sa debtor. Pero kapag naman kulang yung pinagbilan, may utang pa rin si debtor kay creditor. Next, if the chattel mortgage is constituted as security for the purchase of personal property and not for the loan payable in installment, no deficiency judgment can be asked and any agreement to the contrary shall be void. So this is just an exception to the general rule. So I hope that you've learned something from me in our discussion of our module number 12. So for your tasks for this particular module, I want you to make a 2-minute video, minimum of 1 minute kung kaya nyo, maximum of 2 para hindi naman sobrang tagal. Okay? And discuss the differences between pledge, mortgage, and chattel mortgage with your blindfold on your eyes. Okay. So again, ano ang inyong gagawin? Discuss the differences between pledge, chattel mortgage, and real mortgage. Na habang kayo ay naka-blindfold at walang binabasa. So maximum of 2 minutes. The first five to comply, number 12. First 5 to comply will receive, other than having grades in the oral recitation, will receive +5 sa second quiz. Bakit second quiz? Kasi yung first quiz natin, quiz all you can. Hanggat maka-perfect ka, wag mong tigilan. Pero kung hindi ka pa rin nakaka-perfect, gusto mo nang tigilan, nasa sa'yo yun. Ang point ko lang, 1 to sawa yung trial. Kaya there's a big chance na maka-perfect ka. So what's the point of giving you +5 in something na alam kong mapa-perfect mo? So i-quiz number 2 natin tong +5 na to. So again, that you just have to post your recitation in the comment section of this post. Okay? So see you again in our next discussion. God bless you all.